Hi, it's Alison from the Law School Toolbox. Thanks for joining us for the Second Semester ReBoot series. Let's do it. Now let's talk about what to ask your professors when you talk with them. So what should you talk about? Here's a list. Number 1, did you spot the issues? As we've discussed, issue spotting is one of the most critical exam-taking skills. If you don't spot the right issues, you're immediately starting in a hole when it comes to the acquisition of points. For example, if the question is about negligence, you can write the most beautiful battery answer imaginable, and you won't earn a single point. You have to identify the correct issues and see the sub-issues and slightly hidden issues to really do well in a law school exam. So the first question you should ask your professor is whether you missed issues and how that might have impacted your grade. Of course, if you have your exam answers, you should already have identified places where you miss issues, which you can just confirm with your professors. Most final exam questions have a couple of main issues and then some minor issues that your professor included to see whether you can put all the puzzle pieces together. Identifying the issues you missed will help you understand your performance overall. For example, you may have done great on the issues you wrote about, but your score was inherently capped at a certain point because you didn't write about all the issues. Because issue spotting is so important, starting with this question helps frame the rest of your discussion with the professor. Now next, you want to talk about how thorough and accurate your rule statements were. Because once you've spotted the proper issues, the next step is to have accurate, complete rule statements. An accurate rule statement demonstrates your understanding of the rule and also sets up your analysis of that issue. Ideally, your rule statements should be separated into elements, so you can address these one by one in the analysis section. That's the basics, that's step 1. An advanced option is to include, where relevant, some explanation of the rule, or to talk about the development of the rule to show the evolution of the law. For example, maybe there's a traditional rule and a modern rule. If you include both, that gives you materials for a policy argument if this rule happens to be unsettled in your exam jurisdiction. Although a majority of the points available on an exam will be in the analysis section, professors look to rule statements to ensure you understand the basic law. You should discuss with your professor the accuracy and thoroughness of your rule statements to ensure you're earning the most possible points on this portion of your exam. If you can review your essay before you meet with your professor, compare your rule statements in your essay to those statements in your outline. If they match, but the rules were wrong, this tells you need to work on outlining. If they don't match, you know you need to work on your memorization and retention of the rules. If you don't have access to your exam beforehand, consider bringing a copy of your outline with you and doing this comparison on the spot. Now, next, we want to talk about whether you used all the legally relevant facts in your analysis. After you've identified an issue and laid out the legal rule accurately, it's time for the real meat of your essay, the analysis. Here you want to ensure you used all the legally relevant facts. Typically, this means you'll use all or almost all of the facts in the hypo in one way or another, but your professor may have included some background facts that aren't really that relevant or some red herrings that are designed to lead you off course. Ask your professor how well you did at pulling out the legally relevant facts and which facts you missed. You may have already discussed this in step 1 because missed facts typically lead to missed issues. To have the most thorough analysis, you need to discuss all the legally relevant facts. Spotting them is a skill you'll need to work on throughout your entire time in law school, and this is also a major component of being a practicing attorney. So ask your professor whether you discussed all of the legally relevant facts, or whether you could have used more of them to bolster your analysis. If your professor provided you with access to a model answer, or to the top student answer, carefully compare your answers to their answers. What did they see that you missed? After you're clear on what facts you missed, it's time to talk about the quality of your analysis. It's the quality, depth, and thoroughness of analysis that separates the good from the great law students. This fundamentally is where you show you have what it takes to think like a lawyer. Strong analysis includes a discussion of all legally relevant facts with an eye to considering both sides of the issue. Answering a law school question, of course, is less about coming to the right conclusion and more about fully analyzing the issue, sometimes referred to as getting to maybe. If you skip steps, your professor will often say your work is too conclusory. This means you drew the conclusion too quickly without showing enough of your thinking along the way. Ask your professor how thorough you were with your analysis. Did you analyze both sides of the issues? Did you consider relevant counterarguments? Did you write towards your preordained conclusion? Or did you allow your analysis to naturally reach its conclusion? The answer to these questions will reveal how thorough your analysis was and where the gaps are between the level of your analysis and your professor's expectations. The next thing you want to talk about is structure and organization. A well-structured essay is easy for your professor to read, and it flows logically so that you're laying out the analysis in a way that makes sense and connects the dots. There are a number of structural mistakes we see in 1L essays. The first is the rule dump. Having spent lots of time and energy memorizing their outlines, students will use the first part of the exam time to regurgitate every single rule they learned during the semester on the first few pages of their answer. From there, they will begin to answer the question by crafting a narrative of what happened and what the answer should be, given some of the rules laid out in the rule block. Sometimes these rules will find their way into the narrative, but usually they're buried in a conclusion. For example, a student might write, "This is a unilateral contract because the method of acceptance is performance." Now, instead of structuring the essay to reach this conclusion logically, step by step, they just state the conclusion as part of the narrative. This is generally a mistake. Here's a far better answer that you could have written that reaches the same conclusion. The issue is whether Sally accepted Ben's offer when she mowed his lawn. In a unilateral or one-sided contract, one party, known as the offeror, makes a promise in exchange for an act or abstention from acting by another party, known as the offeree. If the offeree acts on the offeror's promise, the offeror is legally obligated to fulfill the contract, but an offeree cannot be forced to act or not act because no return promise has been made to the offeror. After an offeree has performed, only one enforceable promise exists, that of the offeror. A unilateral contract differs from a bilateral contract in which the parties exchange mutual promises. Ben stated he would give Sally $10 if she mowed his lawn. A contract requires an offer, acceptance, and consideration. The offer here was Ben's statement that he would give Sally $10 if she mowed his lawn. When Sally mowed the lawn, she then accepted his offer. Because Sally accepted Ben's offer by performance, mowing the lawn, a unilateral contract was formed. This answer, in contrast to the first one, walks through the analysis step by step, stating the legal rule and applying it directly. Clearly, it's going to get far more points than the bare conclusion in answer 1. Another common mistake is the above only minus the rule dump. This is the purely narrative response. Frequently, this response will be a recitation of the facts deemed relevant by the student, along with their prediction of how the court will hold or what the lawyer should advise their client. The conclusion with a buried rule can make an appearance in this answer as well. This approach is even more problematic than the rule dump because you're not even stating the legal rules. Without those, there's nothing to work from, so your analysis will inevitably be all over the place and is likely to earn many points, if any. Neither of these structures are appropriate legal analysis. Legal analysis requires a rule, analysis, and conclusion, like the example answer we just reviewed. Approaching the question piece by piece and working towards a conclusion is the key. Ask your professor if there are places you could have structured your answer more persuasively. Now, and relatedly, review your answer and ask your professor about your use of IRAC. IRAC, or Issue, Rule, Analysis, and Conclusion, is the most basic structure for legal analysis in law school and beyond. There are many different riffs on this with various acronyms, including CRAC, which substitutes a conclusion for the issue at the front, more of an advocacy style. CREAC, same as CRAC, only with the incorporation of rule explanations. TREAT, which uses the phrase thesis instead of conclusion, and so on. But you'll note that all of these include the R, the A, and the C. Ask your professor to discuss how well you used IRAC, if at all, in your answers. Generally, a larger issue requires that smaller issues be analyzed before the larger issue can be decided. To accomplish this, as we talked about, you want to embed smaller mini IRAC paragraphs within the larger IRAC structure. For example, if the issue is whether defendant is liable for negligence, you'll have to separately analyze breach, duty, causation, and harm. These subparts should all be handled separately and distinctly. Ask your professor how well you handled major issues and their minor issues when writing your essay. If you strayed from IRAC and wrote in a more free-form manner, it's likely you lost points in your analysis, so this is something to work on. Finally, before you leave, ask your professor if there's anything else they see that you should work on. Even if you've tried to cover everything, they might see a totally different problem, so that's something you always want to be aware of. Your goal here is to look for common themes. Chances are, if you ask each of your professors these questions regarding each of your exams, you'll start to see similarities across the board. Of course, you'll perform differently on each exam, and not all answers will have the same issues. Maybe you understood the material better in torts than you did in Civ Pro, etc. However, even with these disparities in understanding, there are likely to be common issues on all of your exam answers. These common themes show you some key areas to target for improvement, and it's likely you'll see across-the-board progress if you fix them. As you talk with your professors, pay close attention when the same things are mentioned more than once. If they're all telling you the same thing, it's probably a pretty good idea to listen. Now, the final step in this diagnostic phase is charting your personal strengths and weaknesses. Again, this will be used later to help you build your strategic plan for the semester. The goal of the diagnostic phase is to have a thorough understanding of what worked and what didn't work in the first semester. We want to know where you succeeded and where you still have opportunities to improve. You should take the information from the meetings with your professors, along with the information from your self-reflection and self-assessment, to figure out your strengths and weaknesses. That way, when building your strategic plan, you can make sure you're working on exercises, practice problems, and so on that focus on your deficiencies, while adjusting your preparation to ensure the best shot at success. Now, keep in mind, the diagnostic phase is hard. It's hard to gather the information, and it's hard to deal with the seemingly negative information about your performance that's going to come at you. However, try not to take it personally. Law school exam writing is a learned skill, and it's something you can definitely get better at. Keep the first semester in context. This is a learning process, and there is no expectation of perfection right out of the gates. Law school is a stressful and uncertain time that takes a while to get used to. By undertaking this evaluative process, you're positioning yourself for greater success in the future. Use the diagnostic phase constructively to gather what you did well and figure out where you need to improve. Use it as a starting point for working on your legal skills and developing a plan for moving forward. The past is the past. Don't dwell on it, but do learn from it to make sure your future results are better. We're here to help, and we know you can do it. Thanks for watching, and please subscribe. Hit us up at lawschooltoolbox.com to find out more about our one-on-one tutoring help.